We're now live.
Okay, good morning everybody and welcome to this Norwich City Council Licensing Subcommittee. It's Friday the 11th of September 2020. We have one item on our agenda this particular meeting, and that is the application for grant of premises licence, Daker Drinks, 27 St Benedict Street, Norwich. Okay, we'll kick off with apologies for absence, please. And there are none. Declarations of interest, again none. And straight on to the main item.
Excuse me, I will just say John Dracup couldn't make it, but I think he did inform you that I was speaking on his behalf.
Yes, thank you. We have, yes, I believe you have a statement to read. Okay, so I'll just do some introductions and then we'll crack on with the business. My name is Ian Stuteley, I'm the chair today. We have Councillor Caroline Ackroyd, Councillor Adam Giles, who are members of the committee, Tiffany Bentley, who's our licensing officer. We've got David Lowens, who is a solicitor and legal representative for us today. We have Oliver Chapman, who is the landlord of 27 St Benedict Street, Gail Watling from the off licence on the road, the general stores on the road, and Matthew Dakers, the applicant. Okay, first of all, I'll hand over to Tiffany, who will read the report, please.
Okay, thank you. So the purpose of the report is to determine the application for the grant of the premises licence, Daker's Drinks, 27 St Benedict Street, Norwich. Members are asked, in accordance with the delegation of licensing functions contained in the Norwich City Council Statement of Licensing Policy of the Licensing Act 2003, to consider the application for the grant of the premises licence in respect of that premises, following the receipt of relevant representations. The applicant is Daker's Drinks Limited. The application seeks to allow the licensable activities, times and opening hours as set out in the application form, which is attached at Appendix A. This also includes the steps proposed to promote the licensing objectives, which is the operating schedule. And then just as in addition to that, there was a colour copy of the plan has been circulated earlier this week. The relevant representations. The responses from the responsible authorities are as follows. Police, no representations. Environmental protection, no representations. Fire officer, no representations. Planning officer, no representations. Area Child Protection Committee, no representations. Training standards, no representations. And the Primary Care Trust, no representations. Representations objecting to the application have been received from 5 local residents. Copies of those representations are attached at Appendix B to the report. Attached at Appendix C are the elements of the City Council's local licensing policy, which are considered to have a bearing upon the application. Attached to Appendix D are the elements of the national guidance issued by the Secretary of State that are considered to have a bearing on the application. In determining the application, with a view to promoting the licensing objectives, the subcommittee must give appropriate weight to the steps that are appropriate to promote the licensing objectives, which are the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. The representations, including supporting information presented by all the parties, the guidance issued under Section 182 of the Licensing Act 2003, the national guidance, and the Council's own statement of licensing policy. The subcommittee must take such of the following steps as it considers appropriate for the promotion of the licensing objectives. Grant the application as asked, modify the conditions of the licence by altering or omitting or adding to them, reject the whole or part of the application, and if I may just insert one that's not on the report, the other option, or one of the options is to refuse to accept the proposed DPS. Subcommittee is asked to note that it may not modify the conditions or reject the whole or part of the application merely because it considers it desirable to do so. It must actually be appropriate in order to promote the licensing objectives. The representations received appear to relate to issues that fall under the licensing objectives. The subcommittee is directed to paragraphs 20 and 24 of the local licensing policy as Appendix D, which contain examples of factors that impact on the licensing objectives that the applicant could consider when addressing these issues. These paragraphs also contain examples of control measures that may be taken into account in operating schedules, having regard to the type of premises and all the licensable activities. Subcommittee is also reminded of the contents of Appendices 2, 3, 4 and 5 of the local licensing policy, which are not reproduced in this report, which contain pools of model conditions relating to the 4 licensing objectives. And that concludes the report. You're on mute, Chair, so we can't hear you.
Thank you. Sorry, I didn't realise I was muted. Yes, can you just return to point number 7 and the additional bullet point there and repeat that for me, please?
Yep. So the kind of insert to that is another option is to refuse to accept the proposed DPS.
DPS. Okay, thank you very much. Okay, Matthew, Mr. Dakers, I'll turn to you first and ask you to tell us a bit more about your application and what you would like to do with this premises, please. If you just wait until you're unmuted, then you can proceed.
Good morning, everyone. I hope everyone's okay, and it's a lovely day today. So thank you very much. Yeah, a little bit about myself. So my name is Matthew Dakers, and I'm the brother of the current tenant, Mickey Dakers, of address 27 St. Benedict Street. As you all can imagine, with coronavirus and what's happened recently, a lot of things have made a lot of people try to adjust and change what they do and how they do things. The reason for the application was because between myself and my brother, I've worked in the hospitality industry for over 25 years, and I currently own a premium gin, and I also own a liqueur. 2 brands that have been affected very heavily by the coronavirus situation. And whilst talking with my brother about kind of certain scenarios and other kind of any kind of things that we could think of that could help both of us in our current situation, my brother suggested that we maybe start trying to sell some of the gin from the shop, acting almost like an off license. Originally, the idea was to split the shop and share it amongst both businesses, even though I know that the tenant is still Think Property. There's also equity partners as well, registered there as well as a business, which has also got an interest in my businesses. So it was really just trying to apply for a license to give us the ability to explore different avenues to maybe start doing other bits, using the word like diversify. His business and mine to work together, because we're brothers, and I guess that's what brothers do, is try and help each other out. So that was the original reason why the licensing, and the reason why the licensing application is in my name, not his, is because of the experience that I have in this sector. So he was very happy for me to act on his behalf and apply for the license, first of all to see whether or not it was something that could be done, and then we were just going to move on from there. So that's really why the license was originally applied for. I don't think I have anything more to add to that, I think. Okay,
thank you. I think we have a few questions for you about your application. And I'm going to start with I think actually you've answered part of it. We have a representation from landlords who we'll speak to in a moment, to say that you're not the tenant, and that they don't support the application. Have you spoken to them about this?
Yeah, this is something that I wasn't really aware of at the time. My brother, I think at the time, believed that it was okay. He also believed that he had given enough communication to the landlord. There was an email communicating the desire to apply for a license. It was only when I actually got the rejection or the objection in email that I informed my brother. I was like, "Are you sure you've actually communicated this appropriately?" And I know that there's still communication ongoing right now between my brother, the tenant, and the landlord and his agency right now as well about what to do next, because you know, in an ideal world, this is actually quite embarrassing, obviously, for me sitting here, you know, and my brother knows that as well. So I know that there's still communication going on between him and the landlord about other paths that we can find to find a kind of a resolve to this. When I look at the objection, though, from the landlord, the objection is clear. It's that I'm not the tenant, which I'm very aware of, and I'm very happy. I've kind of announced that as well today. So if the objection is about the tenancy, like I said, my brother is the tenant and his name is Mickey Dakers, and the company that we've tried to register under is Dakers Drinks, which he is a silent partner in. So it's the only thing I can think of as the resolve. But yes, it's very embarrassing, and I'm still hoping that we can resolve it between us and the landlord about this.
Okay, thank you. So the property at the moment at number 27 is Think Property. And that is an estate agent.
Yes, that's correct. My brother owns an estate agency where he currently has 2 offices across the Norfolk region.
Okay, thank you. So your intention is to maintain this shop as an estate agent, but also to diversify within that shop and sell your brand of drinks from it. Is that correct?
Yes, potentially. Yeah, that's the idea. And then also trying to combine with business. I know my brother is interested in trying to use it as well to add on as added value to the property services that he has as well, maybe. I'm not sure how he plans on doing that. I think it's more about gifting things to some of the people that buy the properties as well. But either way, we are both, the plan was always to keep the estate agency there as a representation, and then also have the option to be able to buy bottles of gin maybe as well. And that was the plan, yeah.
Okay, so how do you propose to advertise the fact that this will be an off license for your brand of drinks? Will there be livery on the shop front?
At the start, probably not. I think it was more to do with kind of walking before we run. There was definitely going to be the idea of kind of announcing like a pop-up kind of style business where, you know, it's there for now, and if there was any popularity to it, or if it was welcomed by anyone, then obviously it's something that we would feel a bit more confident in installing a bit more strongly. The shop itself was going to be split into kind of half down the middle, where as you walk in at the door, you would be, you know, there'd be like a kind of I guess a counter where you could purchase the bottles of gin and some shelves displaying them. But on the left side, there would still be the desks and the sofas where the estate agency could still operate as well. And that was really how we were going to do it to start with.
Okay, thank you. I'll hand over to other members of the committee for any questions that they've got. I'll start with Councillor Ackroyd, please. You just wait for you to unmute or unmute yourself.
Yeah, just further to what you're saying about selling bottles of gin, you also mentioned the possibility in the future of having tastings in the premises. So you feel that the premises are large enough to be able to have people come in, do some tastings, buy, that would work? Because you've asked for a dual license, haven't you?
Yeah. With that, at the time, it was kind of like when I was applying for the license, all kind of possibilities of the future were considered. I didn't want to leave it off and have to come back to it and ask. So, I mean, under the current situation, no tastings will happen, I think, anywhere. And then it's getting worse, obviously, and I'm kind of very observant of that. But it was more to do with what could be done in the future. So yeah, there were potentially ideas of having tables where you could sell tickets and do tastings where they could essentially buy the bottles afterwards at a discount price. Maybe these are some of the things that I've seen in other similar business models that, you know, kind of encourage people to not just come out and try something, but also buy something.
Okay, thank you.
Okay, thank you. Councillor Giles, do you have a question?
Thank you, Chair. For my first question, we have a representation from a resident called Andy Farrow making an allegation that you've been operating an unlicensed, off-license from your own property. I wondered if you could come back on that. Thanks.
Yeah, sure. And I'm actually quite glad that you asked about that. I have no idea who Andy Farrow is, but I do know that unfortunately, it feels like he has a personal thing against me. I'm aware that he has contacted my ex-employers and that he's also made numerous comments on social media and reviews on Google negative about myself and my. Everything in his email is false. Every part of information that he has is false. So I'm not running an illegal business from anywhere. I start up Cocktail Canaries, which is a cocktail delivery business, which is licensed and registered with EHO. Even though from what it looks like, he's trying to be a detective and find out why my name is connected to it and where. The business is registered in Elsham under my mother's address, and where the license that we're making the drinks under is not my personal name. It's under my business partner's name, Danielle Wilson. So everything is available on the internet. I just think that Andy Farrow, unfortunately, doesn't know who I am or what my business is about and has made it a personal project to come after me. But everything in his email is completely false, 100%.
Okay, thank you for that. Right, for the moment, I think I'll turn to the other members of the public who have objected to this, and I think at this stage it's probably suitable to talk to Mr. Chapman, if you're available, please, and then perhaps you can just talk about your position and why you object to this license application, please.
Thank you, Chair. So the landlord's position is that they, contrary to what has just been said, the first that we knew about a premises application was when we found it on the Norwich City Council website. I believe that was the 21st of July. That was when we saw it anyway. We knew nothing about it whatsoever. I didn't know who, obviously I recognised the surname of Matthew Dacres, but didn't know anything about it. As Matthew Dacres has said, he is not the tenant of the property. I'm slightly wary of giving out what is otherwise confidential information about the tenancy because it's not public information. Suffice to say that I can confirm what Matthew Dacres has said, which is that Think Property Limited are the tenants of this property as an estate agency. And a director of Think Property is Mickey Dacres, who is Matthew Dacres' brother, I'm told. I, on behalf of the landlords, wrote to Think Property Limited and asked them what the application was about because we didn't know. I had to follow that up, I think, on the 3rd of August and eventually had a reply saying it's just a venture between Mickey Dacres and his brother. It's nothing to worry about. I spoke to the landlord. The landlord was concerned. His concerns are twofold. Firstly, that again, I'm wary of giving away confidentialities under a lease which is not in the public domain, but this is not a permitted use under the lease. Secondly, it was really more a courtesy thing that no one had actually spoken to us beforehand and said, if we were to do this, how would you feel about it? So it wasn't a great footing to get off on. And as Matthew Dacres has said, it's rather embarrassing to be sat here having to air laundry in public. Put simply, if someone came to the landlord and said, we would like to rent this shop and we would require a premises license, the landlord would have a standing objection because he doesn't want that particular sort of use in his shop. He owns the parade of the shops there from 25 to 31 and the freehold interest in the flats above. He's owned it for, I believe, 20 odd years. And he is not interested in having a licensed premises in one of his shops.
Okay, thank you very much. Mr. Dacres, would you like to respond to that briefly, please?
There it is there. Sorry. Just clicked on mute. Yeah, as Oliver mentioned as well. Yeah, very embarrassing. So the courtesy thing I thought had been done, and I can only apologize for my brother. I thought, I believed, and I think he believed he was operating and working under the kind of the way that he could under his own tenancy. So I don't think anything, the courtesy thing is just such a shame that it wasn't done sooner. But permitted under the lease, it is believed that actually there's nothing under the lease that objects a license being applied for genuinely. But I think the main thing is the courtesy, which I feel really embarrassed about, and I wish we would have spoken more with Oliver and his and the landlord directly. But I do know that there are emails currently going on right now between us trying to resolve this in the best way possible. Obviously, kind of with the objections or with the objective that we have with applying for the license and hoping that the landlord will overturn his decision. But unfortunately, it wasn't done in time before today. So one of the things I was going to ask for, if potentially how far this goes today, was to see if we could delay it to allow those discussions to continue with us. But that's up to the committee and the chair.
Right. Okay. Well, we have we've started the meeting, so we will proceed to the end. But obviously we have a situation here where there's potential for you to be granted a license and then not be allowed to use it. And I think that's an issue between yourselves and the landlord, and not part of the licensing committee. And in fact, that objection is something that the committee can't take into account because it doesn't relate to the licensing objectives. Okay, if I turn now to Ms. Watling, first of all, you have a statement, I believe, to read out from one of the other objectors. I think perhaps we'll start with that, and then we'll talk to you about your own objections, please.
Okay. Okay. So this is from John Dracup. I live on St Benedict Street. I wish to formally lodge a motion against a pending alcohol licence for Mr Matthew Dacres, trading as Dacres Drinks Limited. I'm absolutely against this licence being granted under any conditions whatsoever and would ask you reject this application in full. Not only does St Benedict Street not need any more licensed drinking establishments, as there are already a dozen of restaurants, bars and other venues along the same street that allow alcohol purchases, but this will simply encourage more abuse of alcohol that already goes on in the street during the evenings and weekends. St Benedict Street has attempted over the years to clean up its image. The sight of broken glass bottles and glasses are all things residents should not have to tolerate. Most of the businesses along the street are decent and noble, but the problems associated with alcohol abuse still occur, as does the noise. I work from home and I would like to remain enjoying my home in comfort without having to worry about another premises encouraging the consumption of very strong alcoholic beverages. And this licence will encourage it, because the business primary aim is to make money. That is why they have applied for this licence in the first place. They have no interest in the affairs of the people who live and work here. Their aim is making money, and alcohol is a good money spinner. At the moment, 27 St Benedict Street is an estate agent's. So why are they needing to convert this into an off licence? The shops either side are a comic book store and a hairdresser's, both venues that have lots of children and teens amongst their customers. It would be hugely unsafe for those businesses to have to deal with potential drunken idiots whilst they try to serve their young customers too. Having another drinking establishment selling premium spirits, which is nothing more than code for very strong or potent alcohol beverages during the daytime and evenings, is not something the local council should be encouraging. Look at what happened to Prince Wales Road as a prime example. It's a no-go zone for many people, myself included. I do not want this to happen on St Benedict Street. I therefore ask you to vote against the application, deny it in full. It will only bring detriment and disaster to the area and nothing positive. Thank you for listening.
Okay, thank you for that. Before we talk to you, I'd like to invite Mr. Dacres to respond to that on the basis of there's a couple of licensing objectives covered in there, the crime and prevention of crime and disorder and public nuisance. Can you respond to those, please? How your business will operate to mitigate those concerns?
Yeah, of course, definitely. After speaking with the Norfolk Constabulary about the licensing objectives, it was actually advised to increase the license slightly under certain conditions, which I'm more than happy to meet. If anything, one was to have CCTV operational that can record up to 28 days. It was also to make sure that we have a signage in the window preventing and saying that the use of alcohol in the streets is prohibited. All staff who would be working in the in the unit, I guess, will all have licensing training as well, which has to have evidence to that as well. So the plan would be to make sure that every person who is handling or handling any alcohol at all has a personal license certificate to them as well, so that they're fully aware of the licensing objectives. There's also, the door is also locked as well. It's not an open door where you can just walk in and walk out unless we leave it open. And the plan was always to make sure the door was always remained shut and locked, preventing just anybody walking in as well. And we'll also have a challenge 25 policy, which is very common, I think, everywhere, to answer the thing about children, I guess, as well. I also want to pick up a little bit about the email as well, if I can, if I've got time. Some of the things that were mentioned are, you know, I understand Mr. Dracup's objection and completely relate to it as well, because he's a resident, so I can understand not knowing or understanding what the business could be, you know, something that he was worried about. But dozens of restaurants and bars already on the street. I mean, my time spending on the street of St. Benedict's has already showed me that some of them are already closing. So, you know, the idea of that there are a dozen of restaurants and bars currently right now, I'm not sure with the current climate if that will stay the same. I have no intention whatsoever to supply alcohol to drunken people. And the description of it being a drinking establishment is definitely something I wouldn't use personally for what we're trying to do. And as it says as well, the estate agents, currently it's planned for it to stay and operate in some form as well. So that's the only thing I picked out in the email from Mr. Dracup, and I wanted to answer as well.
Okay, thank you. Ms. Watling, thank you for waiting. Can I ask you now to outline your objections to this application, please?
My main concern, more than anything, is the fact that if the business was to fail or not, happen, and they wanted to go onto bigger premises, that license is always going to be attached to that premises. And although Mr. Dacus is wanting to do high-end drinks, which is fine, that license can then sell whatever drinks they want. And we do our utmost in keeping the white ciders of the street out, because that's not the road we want to go down. And I'm just concerned that if that does get attached to that premises, then that's, you know, they can sell what alcohol they want to in the future. If Mr. Dacus was to move on, or if the business fails or whatever. So that was one worry. And I just want to know if the license is to cover drinking on the street, or is it, you know, because of all the tables and chairs that we've now got down here, are we looking to do tables and chairs outside? Is that something that was thought of? And you know, the police aren't notable down this area quite so much as we'd like, but when they are, they do confiscate drink. I'm always telling people don't drink in the streets, and it should be noted that we are a part of the city centre alcohol-free drinking in the streets. But that's my main concern. Is and just one more query: does there need to be a change of use on the premises? I'm not quite sure on that one.
Okay, thank you. With a view to the planning permission, that would be a separate issue potentially for the applicant. And with this license covers the off sales and on-premises sales, and doesn't include a tables and chairs license, which would be a separate application. So,
but they could apply for that.
There's potential to apply for that, and we can ask, if you like, we can ask Mr. Dacus to indicate whether he has any intention to do so.
None whatsoever. And also in response to the issues that Claire was mentioning as well, I wish I could, you know, rub a magic ball and say these things definitely won't happen. I just know that I definitely won't be doing them. And I remember I did actually have a meeting with Gail personally as well to discuss the plans and the outset. I mean, again, it's all kind of things I can say these things, and I hope that they reinforce the intentions that I have. But again, what Gail's saying is she's right. I mean, if the license gets accepted, then anyone can, but that's not the intention of the application. So, I mean, some of the spirits will be, very highly priced, potentially between 30, 40 upwards of pounds. So, I don't think it will be in the same area of what Gail's talking about. And I can only, give my assurance personally that is not the intention, but I don't know how much that's worth, unfortunately.
Yeah, that wasn't really my issue. My issue is if anything happens and Mr. Dacres moves on or the business fails, that license is attached to that premises, and then that premises can sell basically what they like. Okay,
thank you. I'll turn to David, please. Can you respond to that and what the position would be in that situation, please?
Good morning, Chair. Good morning, everybody. Yes, the licence runs with the premises, subject to being surrendered, subject to being reviewed. Okay, and the process of surrendering, that is surrendered by the current holder, or the holder goes into liquidation and no one manages to pick it up before it exits. But as a generalisation, you're looking at surrender or review. Yeah, okay. Thank you for that confirmation. Do we have any further questions for the applicant or objectors, please? Or would the objectors like to direct questions at the applicant? Mr. Chapman, indicate if you would like to. Okay, no. Gail Watling, any further questions? No. Members, do you have any questions?
Thank you, Chair. In the conditions that you've volunteered to, suggested by the police, Mr. Dacres, in the second bullet point, we've got CCTV to be in operation and cover the main public area of the premises. CCTV footage to record for a minimum of 28 days and be available to police on request. Would you be happy to amend that so between police and on, you include and the licensing authorities as well?
Sure, yeah, 100%. I mean, there's already CCTV there, but yes, I'm more than happy to have that added to it. Yeah.
Thank you.
Okay, thank you. If there are no further questions applicants or objectors, then I think we'll have deliberations and then come back with a determination. David? Chair,
just a couple of housekeeping matters, if you would, please.
Yes, please.
Just to tidy up page 15, then we've got on the prevention of crime and disorder, the applicant company is proposing daily checks by manager and staff. I don't know what the daily checks are intended to cover because it doesn't say.
Thank you. Can you indicate those, please, for us, Mr. Dacres?
The daily checks would be in accordance, I guess, with security of the door, the building, the entrance, stock as well. We were actually talking to the Norfolk Constabulary as well about potentially installing a shutter so that nothing could be seen or anything like that. So I guess it's more just a daily rundown of the building itself, making sure everything is in accordance with the licensing objectives, and any other CCTV as well. The CCTV will have any kind of any movement on or anything like that can be checked on the computers as well. Really just safe and security daily checks. We'll also have EHO checks as well, making sure that fridge temperatures or anything like that we have is of the right temperatures that they need to be, and really, yeah, just daily checks. That is what that would include.
Okay, David.
Thank you, Chair. It's just clarification. Then it says an incident log will be kept secure on site, but says nothing about the incident log, what it's intended to cover, or whether it'll be acceptable to the police or the licensing authority.
An incident log, yeah, will definitely be there in case of any incidents that will be recorded that happen on a daily basis, and will always be available as part of, as part of our responsibility. We'll have a daily logbook that each member of staff will be able to enter in any details or any incidents that happen.
And is it accessible? Do you intend it to be accessible to the Police and Licensing Authority?
Yes, 100%. I mean,
do you wish to change your proposed operating schedule to say that?
Yeah, I'd be happy to. I'm not sure how I do it personally. I mean, if there's any kind of comments afterwards, but yeah, I'm more than happy to change that and include it.
Effectively, you just say now that you are changing it.
Okay, I'm changing it. Sorry.
So we're changing that, Chair, to include accessibility by Police and Licensing Authority.
Okay, yes, thank you very much. Right, thank you. Anything else, David?
When it says there'll be a license holder on site at all times, I'm sure we can guess, but what sort of license holder do you mean?
Personal license holder.
And that's the same in respect of paragraph C, public safety, and paragraph E, protection of children from harm?
Yes.
In respect of D, prevention of public nuisance, you're saying all items will be sold in closed and sealed containers and supplied with bags. How does that work with your on sales, please?
In terms of that, so originally, I'm trying to think actually. So the operated sales, so the tastings, I guess, will always be planned. We would never actually have open containers available all the time. They would just be staggered or staged in certain window frames where people are invited in, and it's ticket only. So we're not planning at all to actually sell drinks to general public walking in on a daily basis.
Do you mean open drinks?
Yeah, we're not. That was never the intention. I think it was a conversation with the Norfolk Constabulary said that they wanted that added in into the license. So.
Right. I mean, it's your operating schedule. I'm just flagging that you're wanting on sales, but you're also promising that all items will be sold in closed and sealed containers.
We will only be selling items enclosed. Anything that is open will be given as part of a ticket sale. It won't be sold as an individual item. So we won't be selling, we won't have a menu of drinks. There won't be any individual drinks being sold like that.
Chair, it's going to be for the applicants to take their own legal advice, but personally, even a disguised sale may well be considered a sale.
Yes, I believe, Mr. Dakers, what we're looking for here is an item perhaps to be added to the prevention of public nuisance list that you've got there, describing how open container sales will be carried out. So at the moment, you've restricted yourself to supply everything in closed and sealed containers with bags, which would not allow you to have a tasting session as things stand.
Okay, yeah, I think I probably got something wrong there then. I can only apologize, and I wish I would have legal representation for that. Yeah, no, I mean, at the time, that's why I think the Norfolk Constabulary spoke to me and said that they advised that get added to the licensing terms so that we could do it. Yeah, I don't have any other answers for that, unfortunately.
Well, this is your opportunity to add something in now to cover that. For example, if you were to say all off-sales items will be sold in closed containers, and then add in something to cover your proposed tasting sessions.
Yeah, I'm more than happy to add something in. I'm just not sure what it would be at this present time. That would satisfy the committee.
Okay, would you like to take a few minutes to have a think about that? In the meantime, Gail Watling is indicating to speak, please.
Yeah, just on that basis, are you allowed to change the application halfway through a hearing?
Chair, it's generally acceptable provided you don't ask for more than you advertised. Okay. You can have less.
Right.
And significantly amending to make sure it works is always sensible.
Okay.
With regards to that, then I would be more than happy to remove the open container and any idea of doing any tastings in the future from the license. It wasn't anything that was, it's not a priority and it's not that important to what we were trying to apply for.
Chair, one way of doing that would be to remove on sales. I don't know, and it's quite a big step, if that's what the applicant is now saying. So over to the applicant for that.
Yes, I'm happy, and I would like to remove on sale in the license.
Okay, so just for clarity, you're changing your application for off sales only.
Yes.
Okay, thank you. Okay, David, are you content that everything's covered now?
There was nothing else obvious, thank you, Chair.
Okay, thank you. So again, I'll thank everyone for attending.
I'll take myself off the video.
Okay, thank you. Thank you everyone so far. There's no further indications of anyone that would like to speak, so we'll pause the meeting for a few minutes while we make a determination, and we will return shortly. The time is currently just after 11 o'clock. I would suggest that we'll need 15 to 20 minutes, so not earlier than 20 past 11, please. Thank you. I'll hand over to officers to remove necessary people.
I'll just be putting everyone back into the waiting room. And members, there is that separate meeting set up for your deliberations. If you could go into that meeting now.
Karen.
You will have to go to that separate meeting as this is still being live streamed for the deliberation. So you'll have to come out of this meeting.
There we go.
Okay, welcome back, everybody. Can I just ask, are we live?
Yes, we are.
Thank you. Welcome back to this committee meeting. It is just after 11:30, Friday, 11th of September. We've reached our conclusion. It was a unanimous decision, and the decision is to grant the licence as amended, and with one further condition that David will describe shortly. I can say that this was a difficult decision for us because of the unusual situation. So we did have to take take aside some of the elements of the objections, in particular the private matter between the landlord and the applicant, and other matters, and consider this application on the basis of the off-licence application, which we believe covers all the licensing objectives. However, it does appear that this may not go ahead because the landlord is currently objecting to it. I'd like to hand over to David, who will describe the legal elements, please.
Thank you, Chair. So, as mentioned, this is a unanimous decision to approve the application as amended, so off sales only. Committee, in summary, notes that the hours are not unreasonable, noting the area, that the conditions as amended promote the licensing objectives as expected of an off-license, that there is antisocial behaviour in this area, but there is no evidence before committee that the activities of the licensee, as opposed to the activities of the public, will increase this. And the committee notes, as is its statutory obligation, that the central government guidance, paragraph 2.21, mentions that beyond the immediate area surrounding the premises, antisocial behaviour is matters for the personal responsibility of individuals under the law. In respect of future changes, then they may or may not occur, but the review procedure is available. That the views of the landlord are noted, but that is a private law matter. That the police, who are the council's primary advisor on crime and disorder implications, have no representations or concerns, provided that the conditions as mentioned are agreed, and they have been. There is an additional condition imposed, namely that a refusals book will be made and kept on the premises, and the premises license holder will record in the refusals book any refusal of service and the reasons for it. That will be kept on the premises, accessible to the police and the licensing authority upon their request, and the data kept for at least 28 days. Chair, I think that was, oh yes, my apologies, and there's a 21-day right of appeal. That's in respect of everyone, those making the representations, and also the applicant noting that imposed condition. Unless there's something you think I've missed, Chair, that's a summary of the decision.
Yes, okay, thank you very much, David. Unless there are any questions on that, I will conclude this meeting for today and thank everybody. Mr. Chapman, please.
May I just ask, and I think I know the answer anyway, is an application for a premises license on a property in which you have no legal interest permitted in the same way that a planning application can be submitted against anyone's property, provided that the owner is notified under a planning application. Is that the same for a premises application, please?
David.
It is, yes. The particular bit of law is the Licensing Act 2003, section 16(1)(a), and this is who the government say may apply for a premises licence: a person who carries on or proposes to carry on a business which involves the use of the premises for the licensable activities to which the application relates.
Thank you, David. It's one of the reasons why it was a difficult application to determine, because we have to effectively disregard that objection because it is a private matter. However, it doesn't mean that it's not valid, and it will obviously be a matter for Mr. Dacres and landlords to settle between themselves. Okay, thank you for that, David. Thank you, everyone, for attending today. I draw this meeting to a close. Thank you.